Chris Bishop.
Well, what a learned contribution by James Shaw. An excellent speech. James Gray, I should say. I've got to say, in stark contrast to the disgraceful remarks by Phil Twyford about 10 minutes ago, after the embarrassing month that he has had being called out for misleading the social housing sector before the election and endorsing the National-led government's reforms in social housing and then campaigning against it and criticising it after it, called out, we found the speech highly embarrassing month for him. So for him to come down to this House and criticise my good colleague Alfred Naro, Mr Speaker, on spurious grounds, he talks about chutzpah, ladies and gentlemen. Well, he had a lot of chutzpah himself, Mr Speaker. Phil Twyford should come down here and apologise to Alfred Naro and also apologise to the social housing sector for telling the Social Housing Conference he agreed with the thrust of what the National-led government is doing in social housing. And I recognise I'm straying a little bit far from the bill, but only following the lead of Phil Twyford, who started with a disgraceful personal attack. But anyway, we know that the Greens don't engage in that sort of behaviour, so well done to Mr Shaw for his contribution to the speech. And Mr Shaw quite rightly pointed out that it's an interesting time to debate this bill because of the pecuniary interest that we are filling out. And I think it's fair to say that Mr Graham did put forward this bill in good faith, and the government did take a look at it in good faith, and it's had a long journey, first introduced in 2010. And I think a previous speaker, I think in the first or second reading debate that I was reading before, noted that this was the first member's bill to prompt a Law Commission paper or an inquiry, and you know that is an achievement. And one day I hope to have a members' bill adopted. I hope that we will just pass it without a 5-year-long gestation period and then have it voted down. But I hope that I will also have such achievements in my parliamentary career. Sir, if I could summarise why the government is not in favour of this bill, it would be for 5 reasons. Firstly, the Law Commission recommended that it not happen. Secondly, there are legitimate concerns, I think, about the safety and the privacy of judges if there was to be a pecuniary interest register. Thirdly, and importantly, sir, there was concern about the chilling effect that a pecuniary interest register would have on the incentive for judges to move from commercial practice or move from the bar to the bench. Fourthly, sir, it's the government's belief that the current law is satisfactory and indeed actually is being strengthened through the Judicature modernisation bill that other members have mentioned. And fifthly and finally, there is no evidence, we believe, that there's a lack of confidence or faith in the judiciary. So I want to run through those reasons, sir. Starting with the first point about the Law Commission not recommending that a pecuniary interest of judges register was required. And as I've mentioned, the Law Commission did issue an issues paper in 2011, and Sir Grant Hammond, who's a former President of the Court of Appeal, and his team at the Law Commission put out a thoughtful paper. I'm not sure if our colleague on the government benches, Dr Mapp, was on the Law Commission at that point, but I'm sure that his expertise and intellectual acuity was at Wiley. My colleague Todd McClay says I'm sure that the discussion of the submissions on that issues paper was considered by Dr Mapp. And then what happened, sir, is the Law Commission also undertook a review of the Judicature Act 1908. And it's actually quite remarkable in some ways that the Judicature Act, which is actually a constitutional act in our unwritten constitution, actually the foundation stone in some ways of judicial review, which is the ability or provides the mechanism by which ordinary citizens or non-ordinary citizens can hold the government and the executive to account. So the Judicature Act was reviewed, in some ways remarkable that it hadn't been reviewed in that time. And they also reviewed the structure and the framework of our superior and lower courts. I won't use the word inferior. That's fallen out of favour as the time has gone on. But the superior and the lower courts, and they did a review of that, and very wide scope to that review, and that has ended up in the Judicature Modernisation Bill, which of course had its second reading last week. And in that bill, there's a recommendation that the heads of the bench develop recusal guidelines and the government agreed with that submission, and that's reflected in the bill. And so that's at the heart of why the Law Commission says that there's no need for this bill essentially to proceed, because there are better ways of managing conflicts by judges, managing the conflicts that judges may potentially have, and the government has recognised that. Secondly, sir, there are real concerns about the privacy and safety of judges. And I don't want to overstate those concerns, because generally in New Zealand we live in a fairly peaceful country. But there are concerns about people being able to use a pecuniary interests register for judges to put at risk the privacy and the safety of our judiciary. That's not something that anybody in this House would want. Some of those submissions, those concerns were reflected in some submissions to the Select Committee. I think I wasn't on the committee, unfortunately. I was not a member, but I think it's fair to say from talking to my colleagues that there was some cognizance of those concerns. There was some recognition of them and some agreement, and so that is another reason why the government's view is that the bill shouldn't proceed. Thirdly, sir, I think it's important to canvass the chilling effect that this bill could potentially have on the ability or the incentive for people to join the judiciary. And the Attorney, sir, the Attorney-General, in his contribution on the second reading of this bill, noted that we have a very, very good judiciary in New Zealand, but it is sometimes quite difficult to persuade excellent lawyers, either in the commercial field or at the bar, to move to the bench. And one reason for that is that a lot of our very best lawyers, some of our top silks, some of our top commercial litigators are on a pretty good wicket, can earn a fair degree of money in their roles that they're in. And for some people, going to the bench does involve a pay cut. So that is one reason, but also there's the concern about workload, and there are some other concerns about particularly being a judge that travels around the country a lot. But we don't lack for good judges. We have an excellent judiciary, I believe, sir, and a lot of judges that I've had the privilege of knowing, a couple, do it out of a sense in some ways of duty and a belief that being a judge is a good way of giving back to the legal system, that they in some ways have a duty to give back and a duty to uphold justice and dispense the Queen's justice. But this is a barrier, sir, to judges making that decision to move to the bench. And the Attorney-General expressed concern about that, and I think that would be reflective of the concerns of the profession, sir, and that's fair enough. Mr. Speaker, the fourth reason is that the current procedures work and they're being strengthened. I've mentioned that already through the Judicature Modernisation Bill. Sir, if I could just touch briefly upon the suggestion from the Green Party, and I think Jacinda Ardern in her contribution earlier also made mention of this, that perhaps the recusal guidelines that the heads of bench are developing could perhaps be strengthened a little bit by including it in the primary legislation. I think Dr Graham is going to move a SOP in that regard. Sir, in my view, that would be to tread a little bit too far on that very fine line between Parliament and the judiciary. And in my belief, sir, it would disturb the comity between Parliament and the judiciary and the recognition of the appropriate lines between those two things. I don't believe, sir, that there is a need to put those recusal guidelines into legislation. I believe, sir, that it's appropriate and constitutionally appropriate that it's left to the judges to do that, and we would be treading too far into the realm of the judiciary if we did that. Fifthly and finally, sir, just to close my speech on a good note, there is no evidence of corruption in New Zealand. Our judges enjoy high levels of public confidence, and one of the, I guess, good things about this bill is it has ventilated some of the arguments about transparency, and it has ventilated some of those issues over the last 5 years. The bill was advanced in good faith. I think there is general agreement it won't be proceeding, but well done to Mr Graham for advancing it, and to the Green Party for their mature contribution to this debate, unlike members opposite.
Claire Curran.
Thank you.